In the past few episodes, we've talked about 3 different cases decided by the Supreme Court, fleshing out the contours of the good faith exception. We talked about United States versus Leon, where police officers relied in good faith on a bad warrant. We talked about Herring versus United States, where police officers relied on a warrant that didn't exist except for a poor bookkeeping error. We even talked about Davis versus United States from 2011, where there was never a warrant at all, but instead the police officers were relying on binding appellate precedent that was later overturned. The court justified not applying the exclusionary rule in all of these cases because that rule would not deter police misconduct and therefore would not pay its way under these circumstances. Now, there are other important cases that we didn't talk about. For example, Arizona versus Evans at the Supreme Court in 1995, where the court held that a computer error that made it seem like a warrant existed still didn't trigger the exclusionary rule. Similarly, Illinois versus Kroll from 1987, where the Supreme Court held that an officer's good faith reliance on a statute didn't trigger the exclusionary rule even when that statute was later overturned. There are also cases that deal with related concepts. For example, upholding a search or a seizure when the officer reasonably relies on a mistake in the law or a mistake in fact. At any rate, we need to always be careful when trying to understand the application of the exclusionary rule to know that it typically will only apply when it serves to deter police misconduct. Now, it's important to note that some states have rejected the good faith exception to the exclusionary rule. Because the good faith exception is not a constitutional rule, just like the exclusionary rule is not a constitutional rule, state courts have every right to reject it. So if you practice state criminal law, please be aware of whether the good faith exception applies in your state. The good faith exception to the exclusionary rule represents a significant contraction in an individual's rights under the Fourth Amendment. To a criminal defense attorney, it's a bitter pill to swallow, just as Justice Alito described the exclusionary rule. The Fourth Amendment, in fact, may never fully recover from the good faith exception and another related doctrine, the third party doctrine. But nonetheless, it's what the Supreme Court has said. We have to understand it as best we can, particularly the limiting principles, so we can try to spot those situations when the good faith exception may not apply when you think it does. We have to know these cases, we have to be able to use them, and we have to be able to advise our clients in such a way that's consistent with what the outcome is likely to be.